you been doing, Robert?
So remember, the Supreme Court has 9 justices. You need 5 in order to get a ruling upheld. It's a simple majority, and as long as the simple majority goes with it, that's it. Chief Justice John Roberts wrote the opinion or the court ruling for this Obamacare, and here's ultimately what happened. Breyer, Sotomayor, Ginsburg, and Kagan ruled together on the liberal side, and they were joined by John Roberts, Chief Justice John Roberts. And that gave the majority 5 to uphold the individual mandate. Now, there were a few things that came out of this. The individual mandate was not upheld as part of the Commerce Clause or the Well-Being Clause. That there was a majority that ruled against it, so those were out because Congress came to them and said, oh, we can tax people for not buying health care because of the Commerce Clause and because of the General Well-Being Clause. And the Supreme Court held, nope, that was not the case. But let's get into what they held on the individual mandate as a tax. So there is a law that came from like 1867 called the Anti-Injunction Act, which basically said that if you are challenging a tax, you have to first pay the tax and then go to court, and then you can get a refund. And the reason is Congress was being starved of its money. The Treasury was being starved of its money. So they passed the Anti-Injunction Act. So if you have a problem with a tax, you first pay it, then you have to get reimbursed if you win your court case. But here's the challenge. In this Obamacare ruling, the Chief Justice and even the liberal justices all agreed that the Anti-Injunction Act did not apply because this was not a tax. But then they went on to say this was a tax and that's why it was legal. So let's get into what they did. So in the Chief Justice John Roberts' opinion on the ruling, so what the court held, he had several areas, several sections. Section 1 and Section 2 were not upheld. Section 3 of the opinion is upheld, and that's where the individual mandate became constitutional by the Supreme Court ruling. So let's go through Section 3. It is a long section, so we're going to go a couple of paragraphs. I'll skip a few paragraphs that aren't important, but I will read a paragraph and then we'll go through parts of it at a time as we go through looking at this. So here's the heading, the top paragraph to Section 3. Section 3 says, the government advances 2 theories for the proposition that Congress has constitutional authority to enact the individual mandate. First, the government argues that Congress has the power to enact the mandate under the Commerce Clause. Under that theory, Congress may order individuals to buy health insurance because the failure to do so affects interstate commerce. That came out of a ruling from an old ruling, 1895, late 1800s, ultimately got ruled on in 1942. A farmer was growing wheat for his own use, and Congress said, we can control you. And he said, no, you can't. The Supreme Court in 1942 upheld, yes, we can control you because you're not buying wheat on the open market affects the interstate market. We can debate that. I think that was a terribly wrong ruling. And at the end of this program, we'll talk about how to fix that one too. But ultimately, Congress can tell you to do something under the Commerce Clause if you're not doing it affects interstate commerce. Now, remember, the Supreme Court held, no, that doesn't apply in this case. It was the first time the Supreme Court began to limit the Commerce Clause because the Commerce Clause has been taken way out of context. But either way, it says so. It affects and could undercut the Affordable Health Care's other reforms. Thank you for watching that video. If you like that, remember to give me a thumbs up and subscribe right up here. For other great content, take a look at our recommended video over here and see our playlist right over there. Remember to go to www.dustyfriday.com for great memes, news, videos, and my podcast available on all major platforms. Thanks, and we'll see you on the next one.